There's an interesting interplay between undue influence and lack of capacity. On lack of capacity, you actually have to prove that the person lacked the capacity to create the document that you're challenging, whether it be a will or a trust. So you have to go to the medical records, and you have to have expert witnesses, and you have to have all this evidence come in, and you have to try and prove that that person simply could not create that trust or will. It can be very difficult to actually prove in court. Not impossible, but difficult. With undue influence, you're not proving that they lack capacity, you're just showing that they had a weakness of mind that then made them susceptible to undue influence. It's not as hard to prove because you're not showing that they were completely incapacitated, you're just showing that they were weakened, they were in a weakened mental state. And that can be enough to successfully prove undue influence. And so that's the interesting interplay between the two. And undue influence doesn't get a whole lot of attention because people focus more on the lack of capacity. But the lack of capacity is actually harder to prove in court oftentimes.